Wall Street Journal reporting the Department of Justice has a criminal probe on FTX, while Bloomberg reporting U.S. securities and commodities regulators are probing whether FTX.com correctly managed client funds. And we're just going to jump right into it. We have right now joining us CFTC Commissioner Kristin Johnson. Welcome, Commissioner, to the show. So I understand, that there may be a probe on handling of client funds of FTX. And can you confirm those reports?
Thanks so much for having me this morning. I'm glad to join you all ahead of an open meeting that we are having here at the Commission today. What I'd like to stress about the current environment is that shocks continue to reverberate across markets. We are seeing mild contagion as institutions that are also engaged in servicing customers in the context of exchanges in trading environments are being impacted by what's going on. I'd also just point out to your point about customer funds, if FTX.com had been a regulated entity within our under our regulatory umbrella, yes, customer funds would have been protected. There would have been liquidity reserve requirements in place. There would have been continuous monitoring and surveillance that is not immediately available because this is not an entity that is subject to regulation in our ecosystem under our regulatory framework.
So you bring up a great point, whether or not regulators can go after the head of a non-U.S. entity. And in the case of BitMEX, we did see regulators go after the CEO, Arthur Hayes. Is that something possible in the case of FTX?
Thanks so much for this question. BitMEX was among the first cases the Commission reviewed as I joined the Commission after being confirmed by the Senate in March. And what I would point out to you is that we are vigorously enforcing in the instances where we can. There is a regulatory gap that you all have talked about numerous times on this program that really limits our ability in the context of spot markets to require the registration, which is the step that I was mentioning a second ago that would have brought FTX.com or any other entity under our regulatory purview. What I'd highlight in terms of your specific question is there is extraterritorial application in some limited context of U.S. regulation, which means it is not feasible to simply hide in a different jurisdiction while defrauding investors who are U.S. persons. And we are certainly prepared in every context to enforce to the full strength of our ability and resources.
Commissioner Johnson, in the case of FTX, and as is the case of Binance, and this is something I've brought up elsewhere, they have U.S. subsidiaries. In the case of FTX, there's a U.S. trading FTX U.S. Binance U.S. is also, there is this belief, or at least this notion that these are separate entities completely from their parent company. The parent companies appear to be unregulated entities that the U.S. government may not necessarily have the ability to regulate. Is that going to change? Is that something that you think that will change in terms of regulations, either between yourselves or the SEC, as to whether or not these unregulated foreign entities can control U.S.-based crypto exchanges or even other types of exchanges?
So as a former law professor, I'm thrilled beyond measure. Your analysis of the business organizational framework and the application of U.S. laws in the context of non-U.S. persons and non-U.S. entities is impressive. A+, A+.
Yeah, well, that's the only A+ I've ever gotten.
Well, I would just simply underscore, I think your question is a great one that we've been wrestling with for quite a while. And I want to take you back to the financial crisis in 2007. And I want to ask you to recall the very complicated charts of Lehman Brothers during its bankruptcy. And I want everyone to just picture in their mind the complexity of having assets custodied in countries around the world and attempting on behalf of U.S. investors to ensure that any value that could be returned to them in the context of some liquidity or solvency crisis that results in a firm not having sufficient resources to satisfy its outstanding debt obligations and being forced to navigate the bankruptcy process. These U.S. investors may face real challenges in their ability to regain access to those assets custodied outside the United States. This is not a new question for us. And in fact, I think we've had a series of instances in recent weeks, from Three Arrows to Celsius Network to Voyager, that really illustrate the lack of preparedness, if you will, in some context, for a number of businesses that are operating in multiple jurisdictions and customers who are exposed to the laws of those jurisdictions.
So those questions are asked, but what's the solution? I mean, what do you think the solution should be, and how quick can we get to it?
Well, on that one, yesterday I gave a speech, yesterday morning at 9 in the morning, hoping that Congress will, as it was contemplating in the context of Title VII, acknowledging derivatives markets are global, and most certainly virtual currency digital asset markets are also global. In this context, it's important that we are able to enforce laws effectively where U.S. markets or the U.S. economy may be impacted. And so in adopting Title VII of the Dodd-Frank Act, I believe Congress intended to ensure that we have the power and authority to do that. In a subsequent U.S. Supreme Court case known as Morrison, there was a standard established that could be interpreted as limiting our ability to do some of the enforcement, engage in some of the enforcement activities we would otherwise engage in. It would be helpful if Congress, when looking at the DCCPA or other bipartisan bills proposed in the House and the Senate, takes up once again the question that you're asking, which is a very sharp and important question. How best to enforce in markets in a way that protects U.S. customers and, more importantly, the integrity and stability of the U.S. economy.
So thank you. This has been very clear and helpful. So we've mentioned kind of a whole range of tools that could prevent this kind of thing in the future potentially. For example, if this was registered in the United States, there'd be more requirements about proof of reserves. Maybe there'd be a way to make it clear about a foreign entity that, affects U.S. markets. But basically what we're going to see now is that this is making headlines all over the world, and probably a lot of lawmakers that were not tuned into crypto now are. And we're probably going to see more of just like a push to do something. Like everyone's going to want to do something, right? So I guess the question is like, how much do you think this is actually going to spur action? Because there's been so much talk of, coming regulation. Do you think that this incident is going to actually make something happen sooner? And what would that thing be? Like, will it actually even be the right thing, or will it just be some totally random thing just to show that we're doing something? Do you know what I mean? Like, what is actually going to be sort of the cause and effect here, practically speaking, in terms of regulation?
Well, one pragmatic thought is never let a good crisis go to waste. Here we see intentionality to undertake or take up these more difficult questions. They are very difficult questions, and they're difficult questions that have been present in digital asset markets since Mt. Gox. Is that a fair reference to make for your audience? We are not unfamiliar with the notion that platforms organized using multinational frameworks might create these kinds of challenges in the context of sorting out whether there was segregation of customer funds, whether or not those funds might have been reinvested. All of those kinds of questions are age-old questions in our markets. And so I think you're right, there may be an impetus to do something, but we've seen a few instances, pretty significant instances occur where there has not actually been action. In this context, I'm hopeful that there will be, that Congress will take up the questions that we've described, as well as those that were already on the table, and close the regulatory gap, giving clear direction to the SEC and the CFTC as to how they'd like for us to proceed, and ensuring that we have the resources to accomplish those tasks. I would just point out that global markets are fragile. The fragility of global markets is illustrated in every instance that we see a significant or several moderate-sized firms experience liquidity and solvency crises. To protect markets and investors, the very best path is clear legislation and ultimately careful, thoughtful regulation adopted by regulators that implements that legislation.
So I know this is a difficult question because it's a very complex issue, but for people who are just having trouble making sense of this whole thing, if you had to choose, like if you had just all the power in the world, like what would be the ideal sort of regulation to address this specific kind of problem, right? Because there are a ton of different things that one could do, but if we're looking at kind of what just happened to FTX, what in your view would be sort of like the ideal thing? Like, okay, if we had this in place, it would be harder for this kind of thing to happen again. Because I think people are sort of struggling with that. Like, what kind of thing might have prevented something like this in the future?
So I want to just point out, setting the really tough questions about what might be happening at FTX to the side, because as of now, I think we don't have perfect visibility. There are lots of rumors and there's a lot of discussion, but it would be helpful to have facts and information. And I will reserve any comment on that until we've had the opportunity to properly engage in those conversations. I would also just point out, though, that LedgerX is a company owned by FTX that is a registered market participant with the CFTC. And for any registered market participant, we engage in a very rigorous series. In fact, today in the open meeting that the CFTC is having, we'll be focused on ensuring the integrity of the entities that operate in our markets, once again, by engaging in a rulemaking process whereby we solicit comments from the broad community, public interest advocates, commercial end users in our markets, large institutions that operate in our markets. And our goal is to use that information and feedback to craft effective, smart, precise regulation that directly addresses the kinds of concerns that we're talking about. They're not unique to one institution. They're not unique to any one market. These are necessary, well-tailored regulations that help to ensure the integrity of individual businesses and the platforms and groups where they engage in trading or exchanges and clearinghouses.
Here's a kind of a follow-up to that line of thinking. So we have Senator Elizabeth Warren tweeting out, the collapse of one of the largest crypto platforms shows how much of the industry appears to be smoke and mirrors. We need more aggressive enforcement. I'm going to keep pushing the SEC to enforce the law to protect consumers and financial stability. But we also have Coinbase CEO Brian Armstrong responding, saying FTX.com was an offshore exchange not regulated by the SEC. The problem is that the SEC failed to create regulatory clarity here in the U.S. So many American investors and 95% of trading activity went offshore. Punishing U.S. companies for this makes no sense. And I know you're with the CFTC, not the SEC, but I suppose the line of thinking is, do you handle this with a hammer or with a sandbox and allowing, this innovation to grow and work with the companies, the crypto companies that want to work with regulators to find a way to have solutions?
So I think the rigorous enforcement point is a really important point, because rigorous enforcement goes to, as was raised earlier, the reality that even in the current moment, both the SEC and CFTC have certain powers and abilities. And under the CFTC's remit, we have the authority to look into markets and to bring enforcement actions where there is fraud, just lying, cheating, and stealing, right? Against entities that might be operating in our markets and engaged in misconduct, material misrepresentation, with respect to what they're actually doing. We have brought more than 60 enforcement actions in the digital asset space in the recent period at the CFTC, and some of those actions involve entities stating that they are investing in Bitcoin or another digital asset and essentially just absconding with customer funds. And in those contexts, what's important to keep in mind is some of those businesses are not legitimately organized. They are not formed or organized as corporations or LLCs or LPs. There are no actual investments. Funds received are immediately used to repurposed for personal use, to buy a yacht or to buy clothes at a luxury clothing store. And so I just want to strongly emphasize that the enforcement piece of this can be, I believe, separated from the development of regulation piece, because with respect to development of regulation, it will be important for the U.S. to have a seat at the table, that to be a preeminent voice in structuring the regulation in this market. And we will do that in cooperation and collaboration with international regulators to establish baseline standards that will ensure the integrity of markets. So I concur with Senator Warren's aspiration and expectation that we will enforce to the full extent of our remit. It would be helpful for us also, as many senators are turning to this issue, that we could begin to get clarity about what they would direct us expressly to undertake in accordance with their understanding of how best to enhance the regulatory framework in securities, commodities, and derivatives markets. I think that we would benefit from that guidance because it will enable us to work hand in hand with the SEC in developing a regulatory architecture, as we have done in the swaps market for swaps and security-based swaps, that will give the industry clarity about exactly what we expect of them and exactly what their regulatory and compliance obligations are.
Commissioner, you mentioned the absconding of client funds, and there could possibly be a probe on the handling of client funds at FTX. So how will that be done if they are a non-U.S. entity?
So this is a great question, and I think part of what we'll have to do is obtain some additional information to truly follow the thread that you raise here. I think it's important to actually have all the facts before making any formal statements about any individual market participants. And to the extent that there are ongoing activities and in conversations, it may not be appropriate for me to comment. But I did mention we're having an open meeting today, and I actually have to run right now to that meeting. So I don't know if this is an appropriate exit or not, but I must go do my sworn duty and vote on two important matters today that actually relate directly to what we've been talking about, crafting refined regulation and international cooperation.
Can I chip in one last question? Tim Masson, formerly of the CFTC, had asked, he suggested having a SRO that would combine with the SEC and the CFTC to and have these self-regulated organization basically oversee the crypto markets, especially given that they behave so much like a little bit like commodities, a little bit like spot markets. What do you think of that idea, and is that something that you think would be pushed forward soon?
I'm tremendously interested in Tim's idea. He co-authored a paper with Professor Hal Jackson at Harvard Law School. 2 weeks ago, I was at MIT on a panel with Professor Tim sent me a nice note sharing a copy of the paper. Professor Jackson and I had a colloquy with a colleague from the SEC who leads the Division of Trading and Markets about this very proposal. I am a firm believer in the possibility of utilizing industry organized structures to facilitate the implementation of regulation. We've been doing this since the early 1800s in the United States with the formation of the Buttonwood Agreement and the creation of the New York Stock Exchange. We've asked market participants organized in the forms of clearinghouses and exchanges to implement rules, to enforce rules, to develop conflicts of interest, margin, initial and variation margin requirements, to establish standards for collateral and for valuation of collateral. These are critical elements that we have in a regulatory dialogue engaged with SROs to effectively accomplish. And this is not an industry-led initiative. It is actually a partnership whereby the agencies, the SEC and CFTC, have directly engaged in oversight of the rulemaking and enforcement processes. So Tim and Hal have written a paper about historically how we've done this. They've written about the rigorousness of enforcement and the rigorousness of the rules developed by SROs. NFA is a great example of one of the SROs operating in the CFTC or commodities and derivative space, and looking carefully at the history of that organization and its exceptional capabilities in effectuating rule making and enforcement among market participants alongside the CFTC is a great example of how effective we can be in mitigating some of the kinds of risks that we've seen in digital asset markets. So I applaud the suggestion. I think it's worthy of exploration.